Imagine passing away today, believing your family is fully protected by your savings. But the very next morning, your bank account is completely frozen, locking your loved ones out entirely. You assume your spouse or children can easily withdraw what they need for groceries or rent. Instead, they hit a brick wall of red tape at the local branch. This terrifying financial trap catches millions of families off guard every single year. Without the right setup, your hard-earned money sits untouched while bills pile up relentlessly around them. Let us look closely at David, a regular 42-year-old father who works hard to secure his household. He thinks writing a standard will solve every future financial problem completely. David assumes his wife Sarah and their young kids will inherit everything smoothly after he passes. Unfortunately, standard legal advice often leaves out a devastating hidden truth about banking rules. When a sole account holder dies, federal and state laws trigger an immediate freeze. The moment the bank learns of the death, all checking and savings accounts shut down. No one can withdraw a single dollar, not even for funeral expenses or mortgage payments. Your grieving family is suddenly stranded without access to the very cash they need. Most people believe a properly drafted will stop this bank freeze instantly. They rest easy at night, trusting that a stack of signed papers protects their family from chaos. But here is the harsh reality that probate attorneys rarely advertise up front. A will does not bypass the bank freeze, because a will only speaks after the court process finishes. Before a will can execute its instructions, the probate court must officially validate it. This legal requirement plunges your estate into a lengthy, public, and expensive administrative courtroom journey. While your will sits waiting for a judge's signature, the bank accounts remain tightly locked. Your family cannot touch the funds to survive during those initial agonizing months. Think about the sheer logistics of paying everyday living expenses without any cash flow. Groceries, utilities, insurance premiums, and car payments keep arriving while your bank accounts stay frozen. Friends might offer temporary loans, but that is unsustainable for months on end. The financial pressure crushes families who expected a seamless transition of their hard-earned life savings. Court fees and legal retainers start draining whatever cash remains available. Probate is notoriously expensive, eating away at the inheritance you spent decades building for your children's future. Thousands of dollars vanish into court costs, filing fees, and attorney retainers. The state essentially taxes your tragedy, taking a massive cut before your family receives a single penny. It feels completely unfair, yet it happens every day across America. Families grieving a sudden loss are forced to fight bureaucratic systems just to buy basic household essentials. Many people make the fatal mistake of sharing their online banking passwords with loved ones. They think logging in after death solves the immediate cash flow crisis. Do not do this under any circumstances. Accessing a deceased person's online account without legal authority violates federal banking regulations and creates massive legal liabilities for your survivors. Banks monitor for suspicious activity, and unauthorized post-mortem withdrawals trigger fraud alerts. This turns a tragic probate delay into a criminal investigation, adding unimaginable stress to grieving relatives. Another common mistake is adding children's names directly to your primary checking account as co-owners. While well-intentioned, this exposes your life savings to their potential lawsuits or divorces. If your adult child gets into a car accident or faces bankruptcy, creditors can freeze your money. Your hard-earned funds become legally vulnerable to mistakes you did not make. Co-ownership also grants them full legal rights to drain the account while you are alive. Never compromise your financial security just to bypass future inheritance hurdles with risky shortcuts. People also assume joint accounts with a spouse solve everything seamlessly. While joint accounts with right of survivorship avoid probate temporarily, they fail if both partners pass away simultaneously. If a tragic accident claims both parents, the joint account immediately locks for the children. Minors cannot inherit directly, plunging the entire estate into guardianship court-supervised nightmares. Every layer of these traditional banking structures works against your family's financial well-being after death. Understanding what not to do is the first step towards securing true protection. You must avoid relying solely on a traditional last will and testament for liquid cash. Wills are powerful estate tools, but they are completely blind to direct bank account mechanics. Do not leave your primary liquid savings unprotected in a single individual name. Relying on default bank policies guarantees your loved ones face months of painful administrative gridlock. Financial institutions follow strict compliance rules designed to protect themselves from liability. They do not care about your personal family urgency when a sudden death certificate arrives. They lock the doors digitally and physically until a judge hands down formal letters testamentary. That bureaucratic checkpoint is mandatory unless you set up the proper legal designation beforehand. Fortunately, there is a powerful financial tool specifically designed to bypass this entire nightmare. It is completely free to establish and takes roughly 10 minutes at your bank. This simple mechanism is called a payable on death designation, often abbreviated as POD. It transforms your standard bank account into an instant transfer vehicle upon your passing. When you add a POD beneficiary to your account, you retain 100% control. You can spend, save, or withdraw your money anytime without asking anyone for permission. Your named beneficiary has zero legal rights to your money while you are alive. They cannot touch your balance, see your statements, or interfere with your daily financial decisions. But the exact second you pass away, the legal dynamic shifts instantly. Your ownership transfers directly to your designated beneficiary without ever touching the probate court system. All they need to do is walk into the local bank branch with your death certificate. Within days, the account is completely theirs, free from court fees and delays. Think about how much peace of mind that single form delivers to your household. Instead of waiting months for a judge, your family gets immediate access to living funds. Mortgage payments are met, funeral costs are handled, and daily groceries remain uninterrupted. Setting up this free form is the single greatest gift you can give your spouse today. Banks do not advertise POD options aggressively because frozen accounts generate lucrative administrative fees. You have to actively request the paperwork or update your online banking profile settings. Most major American banks offer this feature online or through a quick customer service form. It requires basic identification details of the person you trust most with your funds. You can name multiple beneficiaries and even assign specific percentage splits among your children. If you have 3 kids, you can divide the account balance equally or customize proportions. Contingent beneficiaries can also be added in case your primary choice passes away before you. This fail-safe ensures your money never accidentally defaults back into the standard probate system. Reviewing your designations annually ensures your financial strategy matches your current life circumstances. Marriages, divorces, and births mean your paperwork should reflect your evolving family dynamic accurately every year. Never assume your old bank accounts automatically inherited your new marriage certificate updates. Every single account requires its own distinct beneficiary paperwork to guarantee smooth post-mortem asset transfers. Take a moment this weekend to log into your primary checking account dashboard. Look for the Beneficiary tab hiding inside your account settings menu or security preferences. If you cannot find the option online, visit your local bank branch during weekday hours. Speak directly with a representative and ask to add a payable on death designation immediately. It takes less time than drinking your morning coffee, yet it safeguards your family's future. 10 minutes of effort saves your loved ones thousands of dollars in legal expenses. Imagine the profound relief your spouse will feel knowing cash is accessible right away. No court battles, no frozen debit cards, and no bureaucratic nightmares standing in their way. Protecting your family requires looking past comfortable assumptions and taking concrete preventative action. Do not let outdated banking rules rob your children of the financial security you built. Smart estate planning is not just for the ultra-wealthy owning massive real estate portfolios. Everyday workers must utilize these simple banking tools to keep their hard-earned cash fully safe. Every adult with a checking account needs to verify their beneficiary status right now. Check your retirement accounts, savings accounts, and primary checking balances before this week ends. Taking control of these details ensures your legacy remains intact and entirely protected. You dictate how your money flows, bypassing the expensive courtroom delays that ruin unprepared households. Share this crucial financial knowledge with friends and relatives who still rely solely on wills. Most people have no idea their bank accounts freeze instantly upon their passing. Awareness is the first line of defense against predatory probate fees and legal gridlock. Empower the people you care about by explaining why a simple will is not enough. Keep your financial documents organized in a secure place where trusted family members know to look. Clarity prevents confusion during moments of high emotional stress and unexpected grief. Small administrative habits compound into massive security benefits for your household over decades. Taking 10 minutes today prevents months of financial devastation for your grieving family tomorrow. Master these fundamental rules of asset protection and secure your family's financial future today. You have all the power you need to prevent unnecessary court fees and probate delays. Stay tuned because in our next video we will walk through the exact step-by-step process. I will show you how to fill out the form online without mistakes. You will see the exact screens, buttons, and fields required by major banks. Missing that upcoming tutorial means missing the practical roadmap to complete financial security for relatives. Your family's financial safety depends entirely on the proactive choices you make right now. Do not leave their future up to chance or outdated legal assumptions about standard wills. Make sure you like this video right now to support our channel's financial education mission. Your engagement helps us reach more families before unexpected tragedies strike their households. Comment below with the exact word yes right now if you want the next tutorial. Tell us what bank you use so we can cover your specific institution next.